I was just talking to this lady about a custody case that she's going through, and it sounds like she's really been through the ringer. Apparently, her child's father has a string of drug and alcohol-related convictions. He had a founded CPS complaint against him and even has some domestic violence-related charges. And she said something like, I think I probably have it in the bag, but I'm still pretty nervous about this upcoming hearing. And what I said to her was, you may have it in the bag. I don't know this case very well. I just know the brief conversation that I had with her. I'm not the attorney on this case, but even if you have it in the bag, you're still left holding the bag in terms of the cost of litigation. So we're talking about filing fees. If she's filing petitions, we're talking about the cost of the guardian ad litem, attorney's fees, custody evaluators, and plenty of other costs, including missed work and things like that. So whether she wins or loses at the custody hearing, obviously it matters, right? Because we have an abuser on the other side, but it still means that regardless, win or lose, even win, she still loses because she's still paying the costs associated with this ongoing litigation. And it can be a form of coercive control. It's certainly abusive, especially in the custody context, because in most cases, like in Virginia, where I practice, if you have a hearing in the juvenile court and you don't like the result, you can always appeal it. You have an appeal as a matter of right to the circuit court in Virginia. And not only that, but custody and visitation are modifiable based on the best interest of the child if there's a material change in circumstances. So you can find yourself in court over and over and over again on the same basic frivolous issues, especially if he has family willing to fund his case, which it sounds like he does in this case. So just because custody is in the bag, that doesn't mean that you're not left holding the bag.